There we go. Everybody up in here. All right. Hey,
Hey, how you doing?
what's happening? How are you?
I'm fine. You have hyped this up. I am excited. I am ready. We are about to talk about some patents, trademarks, and copyrights.
That's what I'm talking about. Listen, first of all, I just want to thank you for giving us the opportunity because folks don't realize it's not every day you get to speak to a patent and trademark attorney. So we really do appreciate your time, appreciate your knowledge. But before we get into these questions, right? I just want you to tell my followers a little bit about you, about your practice, and what inspired you to become a patent and trademark lawyer.
All right, but wait a minute though. I have a question for you. So you
Talk
mean
to me.
I can't email you the bill for this time? That's what
Oh,
you're
you know
trying to
what?
do.
I was getting ready to say that. You know what? I was just getting ready to say that's correct. I'm glad you said that because folks don't realize that this really could be like a billable thing. But listen,
Yeah.
you're not doing that though, right? Because I'm going to
No,
cut it
I'm
off right
not.
now. All
I'm
right, good.
not doing it. You had too many people here. You hyped it up, so I'll let it slide. So,
Okay, I
but
appreciate that.
I definitely want to thank you because so many people have so many misconceptions about patents, trademarks, and copyrights. But just to introduce myself, my name is Andrea Evans, and I'm the owner of Evans IP Law. I
Okay.
am so proud to say that I am a patent, trademark, and copyright attorney, and I've had my firm for 14 years, and we currently represent a range of clients from independent inventors, entrepreneurs, Fortune 100 clients all around the world. So the beauty of my practice is I'm able to work with clients all around the world because I have what's called a federal practice. So I'm excited about that. But here's what's unique about my experience. Prior to launching my firm, I actually worked at the Patent and Trademark Office as a patent examiner and a trademark examining attorney. So it was my job to examine patent applications and issue them as patents, and it was my job to research and review trademark applications and issue them as trademarks. So I have a lot of good experience and hands-on experience working at the Patent and Trademark Office, and now 14 years on my own in my firm.
Okay. And now you're just dope as you can be. That's what I'm talking about.
Thank you.
You know what? The reason why I really wanted to do this was because, and you told me, I think you kind of hit on this. I really feel that there's a disconnect, and I'm also at fault as well. Before I started my company, Game Sports, I started in 2017. I can honestly say I really did not know the difference between a trademark, a copyright, and a patent, right? And when I'm just out in the community, I'm just at the gym or whatever, and I might see a young guy or a young lady that has a new apparel line, and it might be a name like a unique name that I like, and I always will ask like, "Hey, did you get that trademark?" And a lot of times they'll say, "Oh yeah, I got my LLC."
Right.
I'm like, "What?" So a lot of folks think that just because they have their LLC, right, or the EIN number, that automatically that they are protected, or they have their brand or their business name, that entity trademark. So that's why I reached out to you and said, "Hey, if you can lend us your knowledge to kind of like, to get people prepared, because a lot of folks, they just don't have that paperwork right."
Yeah,
So that's what this is about.
Let's talk about that because that's one of the biggest myths. So owning an LLC or starting a company doesn't mean you own the trademark, and owning a trademark doesn't mean you own the company. And a good example of that is your company name doesn't have to always match your trademark name.
Right.
So the company name could be Nike, but the trademark is Just Do It. So they don't have to match. And the company name is kind of like your domain name. So if I tell you, hey, meet me at 12345 Main Street, that's just the address. But when you get there and look at the sign on the store, it says Macy's. So the trademark is Macy's, but the address is 12345 Main Street. So your domain name is kind of like that address, but the brand is going to be what's big on the site. So there's so many benefits, and like you said, people don't understand it. So I want to make sure that people know if you're an inventor, you should be thinking about patenting those inventions. If you are an entrepreneur and you have a brand, you need to be thinking about trademarking those brands. And here's what can be trademarked. Sounds, like we think of the NBC, doom, 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 that can be trademarked. scents, colors, like you think of red bottom shoes and the Tiffany blue box, words, symbols, even three-dimensional shapes like the Coca-Cola bottle. So anything that your customers perceive as a brand can actually be trademarked. And then last but not least, your written content. So if you're an author, an illustrator, even your websites and your blog posts can be protected with a copyright. So you patent your television, you're going to trademark Sony, the brand name of that television, and then you're going to copyright those scripts of those television shows. So I love this because every single person watching has some type of intellectual property.
Okay. All right. Well, you know what? It's time to get into some of these questions then. All right.
Yes.
So listen, y'all, this is not the type of live where y'all need to be bouncing back and forth, going to this live and then going over to TikTok, checking on the busted down challenge or whatever. Like, this is going to be very informative. She's lending us her time, so please tune in. Get yourself a drink. I have my wine right here. You said I can drink my wine, right?
Oh, yeah. Hey, I couldn't let you drink alone.
All right. Cheers to you. Cheers to you. And let's get into some of these questions here. So what I did was, when I posted this, I said, look, let's open it up to my followers and let's see if we can, give me some of your questions. I'm going to take maybe the top 10 to 15 questions and I'm going to ask you, right? So the first one is, please, and actually kind of already did it, please differentiate the differences or the benefits between trademark, copyright, and patents. Okay. When should each be used and what is the cost that's associated with each? So you kind of talked about it. Okay. Can you kind of talk about the cost as well or no?
Yeah, so okay. So we talked about patents, trademarks, and copyrights. Patent your invention, trademark your brands, copyright your written works. The second part of that question, somebody said, well, what are the benefits? And that's a good question. Why do I even need to do this anyway? Well, here's the way you think about it. So whatever you can do with real property, like your house, you can do with intellectual property. So you can license it, you can assign it, you can sell it. Can you see me? Because I feel like my screen.
I can see you. Somebody just said for me to link your IG in here. Look, this is my first time going live, putting the details up there. I'm usually getting interviewed by somebody, So
okay, well,
you know what?
Well, you can follow me everywhere at Evans IP Law, so I'll just say that. But here's what I want to tell you about the benefits, because people say, why do I need this? Nobody's going to copy my name. I'm small, I'm small. But whatever you can do with real property, you can do with intellectual property. So you can license it, you can assign it, you can sell it, you can will it. So that's some of the key benefits. And then guess what? You can actually register your intellectual property with customs. And so if you think that somebody's going to be bringing in fake something from overseas, that's one of the other benefits. But here's the most important benefit. All of us are trying to create generational wealth and legacies. You can actually will this down in a trademark, for example, as long as you use it and renew it every 5 years, you get to keep it. So when you think of Coca-Cola having the oldest trademark, long when you're gone, your daughter can use the brand, her daughter can use the brand, and it can just go on and on. And the more valuable your business is, the more value that trademark has.
No, see, that's something I didn't know. I didn't know that you could will it down to your children.
Absolutely.
And so so how often do you have to I'm going to be asking you questions too, as you kind of like,
that's fine.
Yeah. So how often do you have to renew a trademark?
So every 5 years.
Every 5 years?
As long as you come back and show that you're still using it, you keep it. And then if you don't, and that's important to keep up with that, because if you don't, it goes abandoned and then somebody else can use it. Because again, you don't have any rights in something that you stop using.
Oh, Lord. Okay. You got to stay on top of the paperwork.
Hey, you on top of it. You're in good hands.
Yeah, I know that. Look, for y'all that don't know, this is my lawyer right here. So her and her staff have been very thorough.
Thank
you. All
right.
right. So must you have an attorney to register your trademark? We all know that's a no. But I mean, go ahead. I'll let you talk.
Well, here's the thing. So like I said, I worked as a trademark examining attorney. Most of the rejections were from people that filed without an attorney. Yep. So even if you go to the patent office site, they'll tell you it's not required, but it's recommended. And, you know, that's like anything. I think about your time, first of all. It takes so much time to figure it out. Now, we were trained for at least a year just to research patents and just to research trademarks at the Patent and Trademark Office. And so when people say, hey, I researched it on my own, you really need to hire a professional, to make sure you're doing things right. So that's the first thing. But here's the big thing about doing it on your own. If you do it on your own, some mistakes can't be fixed. And so the worst thing that can happen is you put it out there, it's public because everybody can see what you filed. Some mistakes can't be fixed. So now you have to start over. You're at the back of the line. Well, while you're at the back of the line, I'm an attorney. I'm being strategic with my client. And I'm saying, hey, Bob's going to the back of the line. Let's file while Bob is at the back of the line. Now you have to pay my client to get your name back.
Wow. Savage. Savage. Okay.
I mean, hey,
I'm not mad at you.
We're talking about some valuable stuff because, you know, people say what's in a name is so much that goes into a name, as we know, which is why people try to play off of each other's names. Right.
Well, to piggyback on that question, must you have an attorney? Someone didn't ask this question, but this just jarred a question for me to piggyback on that. So how would you differentiate you from like a LegalZoom and all these other different entities that's out here that would be, you know, they might think that it might be cheaper route, but please tell the difference from going with you and doing one of these online entities.
I'm smiling because, hey, I'm a lawyer. They're not. So when you read the fine print on LegalZoom's website, they'll tell you we're not lawyers. And you have to be real careful because a lot of companies like that will lure you in and get you in at a really low rate. And what they're doing is copying and pasting what you typed onto their form. You don't have any counseling, any conversation. And the only reason I know about that is because when there are mistakes, those people come to my firm and I have to fix it. And I'm like, oh, if only you would have known about me. So I'm really happy to be doing this because people need to know there are resources out there and don't count yourself out. You know, people assume that they don't need this and make all of these assumptions.
Okay. Next question. I have an idea that I graphically made online. Which patent, right there, that's where I already know this is. Which patent do I get between the design and the utility?
Okay. Yeah, so that's a great question. So there are two types of patents. Well, really three, including a plant patent. Now, plant patent speaks for itself. That's if you invented a new species of plants. But design, you can patent plants.
Damn. Well, let me drink that. I didn't know. Jesus Christ. Ooh.
Wait a minute. You out in the garden out there making something you didn't tell me about?
Yeah, I didn't know. No, I'm not making nothing, but I didn't know that though. Wow. Okay.
Okay. So here's the thing about, so plants we talked about, that's obvious. It's for plants. But design patents only cover the design or the look of the invention. So you come to my firm and say, look, I know a chair has a bottom, a back, and 4 legs. But my legs on my chair look like smiley faces. So I'm going to say, all right, well, you didn't really cause the chair to do anything. It just has a different look. So now we take pictures, the top, bottom, and all different views of the chair, and then you file a design patent. Now, the design patent only covers the look of your invention. And so what that means is if your legs have 5 hearts and Jane wants to make a chair with 1 big heart as a leg, you can't say, hey, that's infringing on my patent. So a design patent is when you're going to just protect the look of the invention.
The look of it, right.
Now, you come to my office and say, hey, I have a chair, but my legs look like hearts, but each heart takes your blood pressure. One detects COVID. One tells you how long you've been sitting. So now the chair does something. So now it's functioning and it's doing something. So it has a look. We still have the drawings, but we're describing them so that somebody can make or use it. So to answer that question, you have to look at if you're just changing the look of something and only wanting to cover the look, or if you really have something that functions. And what I'll say is never assume you have something patentable just based off of what you see on the internet or TV. We have to do prior art research, and that's looking to see what was invented prior to you filing your patent application.
Okay, it's funny you say, because somebody just asks, every now and then, if I see a good question from the chat, I'll ask. Okay. So Dad Vlog asks, what if your trade search comes up taken? Do you pay per attempt? That's a good question.
Well, no. So the whole thing, if I'm understanding that correctly, so if you're doing a trademark search and you say, I want to trademark Andrea, and I say, sorry, Andrea is already taken, then we're not going to even file because you're just going to move on. You know, so that's the beauty of having a consultation. It's no
Okay.
point in gambling. We don't have to even guess. I'm going to be able to tell you before you file, because that's what I said I'm an expert at. I worked at the Patent and Trademark Office. So that's the whole point, that I'm going to do the same search that they're going to do and explain it to you and say, hey, somebody already has it. So no, you don't have to. Now, if you file on your own, that leads me to the next point, right? So you file on your own and get a rejection. Do you get your money back? Absolutely not. So that's another reason you want to have an attorney. You're paying for this.
Okay. All right. Someone just asked, should you put your trademark in your company's name or in your personal name? I guess what would be the benefit of both?
Well, you have the option. So that's a good point too, because people don't know people can own trademarks. So Jane Doe can be the owner, or Jane Doe LLC can be the owner. The key is you have to make sure that the company is a real company. So you can't say, hey, I haven't formed the company, but let's make Jane LLC the owner. Well, you don't have a real owner. So now nobody owns the trademark. So you can have Jane own it and form a company and later assign it to the company. You sell that company, you can assign it back. And the benefit is just going to be what you think. It's who's going to be responsible and liable for it, right?
Right.
So if I sue you as a person versus you as a company, so that's one of those things that you want to talk to with a business lawyer to say, look, what type of business is best for me? But either one, now I'll tell people, if you say, look, it's holding me up, it's going to take me 6 months to go form a company, you probably want to get this in, as a person and later assign it.
Right. Yeah, that's what I was going to ask you. So if you put it, I guess, if you assign it personally to your name, and then later when you start your company, you're allowed to transfer it over to your company name?
Exactly.
Okay. All right. You know what, y'all, let me get on my followers real quick. First of all, y'all already knew to put these questions. I knew y'all was going to do that, and y'all on the chat and messing me up, throwing me off. All right. So Becky Brown girl, she asks, how much of an investment should an entrepreneur or inventor be prepared to retain an attorney throughout the trademark or patent process? I thought that was a good idea. So, I mean, good question. So,
yeah, everybody wants to know about the costs, and I'm glad you asked, because at my firm, we actually charge flat rate fees.
You do?
And so, and so that's one of the benefits. And I do that because I've had to hire attorneys, and it can get real stressful when every time you're talking, your stomach is hurting and all that because you don't know. So what I'll say to Becky, I think you said her name was.
Yeah, Becky Brown girl.
Okay, so what you should do is schedule a consultation, because first you have to understand that the patent office charges fees. Yes. There are 45 different classes, and they group your different products and services in different class numbers. So depending on what you're doing, that's what's going to drive the cost. So it's $250 per class. So first, how many classes do you have? Then you pay attorney's fees. So what I'll say is you can join, click on in the link in my bio, and there's a schedule a consultation button, and then my office can follow up with those forms. And then once we schedule a consultation, we can research it, tell you exactly what it's going to cost, and go from there. And what you can do to prepare is you can actually research on your own, look at Google, see what's out there, go to uspto.gov, but you're still going to want to have an attorney to look at that. And so I see she said that she submitted a trademark recently. So that's great. You got the process going. And if you want, you can always hire an attorney at any time. So another tip, you can actually hire or fire at any time. So a lot of people feel like they have to stick with the attorney, but you don't. And that's the same even with LegalZoom. So if you're watching and you're saying, oh, I'm stuck, you can actually move on to a different attorney at any point.
And you can let them know the process is not hard. Like, say if you did something on LegalZoom, or if you were currently with another lawyer, if they wanted to reach out to you, your staff would basically handle sending the paperwork over to get the transfer for you to basically handle the case. Right. And so it's not a hard process.
And the best part about it is everything is electronic.
Yep.
So filing the trademark application, signing documents, so it's really easy. And then everything's public, so you don't even have to hand over any big documents or say, hey, I can't find something. It's all there.
In layman's terms, for someone that's I guess really just getting into trademark, let's say if someone has an apparel company, right? They have an apparel company, and they want to do a trademark. So that would be classification 25, right, for apparel, right? So come on now. Hold on, let me get it. Wait a minute. Hold on.
Okay, somebody did their homework trying to be a fake trademark attorney.
Come on now. So the question is, I'm kind of piggybacking on this question here because this young lady says she submitted her trademark and she wants to make an amendment. Also, can you add a different class after submission, right? And I was like, nah, you can't. That's where you kind of get stuck. So
yeah.
can you, before you answer that, can you just break down in layman's terms the classes and, different classes break in layman's terms so people understand it?
Yeah, and I do want to break that down because people assume that you check a box and own
Mm-hmm.
the class.
Right.
But really, the numbers don't mean anything in the real world. It's just the way that they classify it to determine what it's going to cost. And
Right.
they're arbitrary. So, for instance, sunglasses are in the same class as software. So they're not
Really?
related at all. That's just where they classify it. But
Wow.
then all the clothing is in one class. So don't think that because you have shirts, pants, shoes, and socks that that's 250 times 4. So that's going to be part of that strategy of figuring it out. Now, the identification manual is public, but also I got to plug my book now that you said
I was going to let you pull that. I was going to let you do that.
No, but the only reason I'm saying it is because the identification is in this book, too. So I wrote all about trademarks.
Right.
And this actually breaks down kind of, from going from just a trademark to like an idea to a trademark, making it strong, and what to expect when you file. So this is on my site, evansiplaw.com/books or Amazon. And this is my best-selling book about trademarks. Now, I have another one about inventing we can talk about, but I want to make sure everybody's clear because the class numbers don't mean anything, and they're $250 per class. And to really answer that question, I want everybody to know, once you file a trademark application, you can delete goods and services, but you can't add any goods and services.
Right.
And so
give an example of that.
Well, I'm going to give an example because the process takes about a year. And so let's say right now you got 100,000 fans and everybody's buying shirts, and you got to go with what your customers want. They start saying, I wish you sold, I wish you had a class about how you started a business. And you're like,
right.
Okay, well, somebody that gets a trademark for shirts doesn't necessarily own the trademark for classes.
Right.
And so if you didn't register that trademark for classes, remember, you only own the trademark for things that are identical and things that are related. So I can have a trademark for Chico, the teacher, and you can have a trademark for Chico, the teacher, for shirts, and we coexist. And
right.
So if you're moving along, it's 2 or 3 months, and you say, oh, shoot, I wish I could add, classes, it's too late. So part of that is that strategy of trying to figure out what goods and services to identify. And you can't just check every box and own it for everything, because in order to get the trademark, you actually have to provide those goods and services.
Mm-hmm.
So you can't just say, hey, refrigerators, you have to show them. Here's a picture of my brand on a refrigerator, and I sold refrigerators. Somebody said, is it an all-encompassing trademark?
Right.
Absolutely not.
Right. No, I didn't think so.
Yeah, because otherwise companies wouldn't have the same name for different things. So I can be Andrea the lawyer, you can be Andrea the shoe company, and we coexist. But if I'm Andrea for shoelaces and you're Andrea for shoes, now that's a problem because they're used together.
Right. Okay. I think you already kind of answered this. What all is needed to get your trademark as far as paperwork? Does the logo have to meet a specific criteria, or is there a statement that has to be attached as to why the trademark is being pursued for a set logo?
Okay, so first, just to clear up that question, there are 2 types of trademarks. Excuse me. One is going to be a word mark, and one is going to be a design mark.
Break that down. That's where it starts getting confusing at.
Oh, yeah. So a word mark is just typed text. So when
y'all, listen to this.
So,
go ahead.
Yeah, because this is one of the biggest mistakes, especially when people are doing it on their own. So if your brand is Chico, and when I look at my tag, it says Chico size medium, and it's just bubble font, script font, Times New Roman. That's just plain words. That's a word mark. So when we file a word mark, you can use those words in any font, shape, style, or color. So next week you get tired of bubble font, you want script font, fine. Next week you want Times New Roman, fine. You don't have to file another trademark application. So that's the first thing. The second thing is when you have a design mark, A design mark is going to have words and designs together. So your O looks like a smiley face, or, you know, you have shapes and stars and stuff around it or something. So words and designs are a design mark. With a design mark, whatever you file has to match the way you use it. Okay. Now, the third option is, let's say you have a star or smiley face as your symbol. So every time people see a smiley face, they think of the Chico brand. You may have to file that separate, because here's the big tip. Everybody write it down. Whatever trademark you file has to match the trademark that you use. So if you file Chico, smiley face, have a good day, all is one trademark, you have to always use it the exact way that you file it. But if you think of Nike, a good way to think about it is Nike has Nike, Just Do It, and the swoosh symbol. Those are 3 different trademarks, and they filed 3 different ones so that they can use them together or apart. Nike on the front, swoosh on the back, Just Do It at the bottom. So that's part of the strategy, figuring it out. And if you file a design in black and white, you can use it in any color. If you file in color, you have to use it only in colors. Yep.
So would you think it would be more advantageous to file it in black and white so you can use it in any color that you want?
It makes sense, but I have seen clients that pay thousands of dollars to have someone blend something to make it a particular color. And they actually do want to file, and they limit themselves to that color, but they're trying to get to that level of Tiffany blue or red bottom shoes. You know, so that's when the color is really going to matter, because remember, you can trademark colors. Right.
All right, I see. I have to answer this because I see they're called the HBCU, so you know we have love for that. Anyway, right?
Definitely. Hey, we got to shout out Spelman, of course. That's my alma mater, and we definitely got to shout out our new vice president.
Without a doubt.
And then if there are any deltas, you know, got to shout out my floor. So now we just have a whole nother live going.
Yeah, shout out to all the D9 out there, all right? I don't want a whole bunch of mess in here. I'm trying to keep this very professional, okay? Shout out to Bowie State University, all right, HBCU. But they asked, so someone can only trademark something that they're actually selling. That's not true, right?
No.
Or is
it? Let me explain that, so I want to make sure you understand. Let's say right now somebody is saying, you know, my goal for 2021 is to launch a business. I haven't done it yet, but I plan to use Andrea to sell shirts. So I haven't done it yet. I can file an intent to use application. So I haven't used it yet, but I intend to. But before they give us the trademark, they're going to ask me to show that I'm using it. Now, you can file extensions in 6-month increments up to 36 months. And if you get all the way to 36 months and you still haven't used it, then you lose it. Because they're not going to give you now. The other option is Bob is sitting on this live and says, shoot, I didn't know that my company name doesn't mean I have a trademark, or I have a domain name, or I've been sitting here using this business name for 20 years and everybody knows me. I need a trademark. Well, you're using it. So when you come to me, we're going to say, okay, let's file the application under Andrea, and you're using it for T-shirts. We give them the dates, and then you get the trademark. So you can start the process and file it as intent to use and then block other people. But remember, even if you file and get the trademark, if somebody can prove that they use the trademark first, they can take it from you. So it's not going to be that you say to me, I already Googled this and I know Chico uses this name, but I'm going to hurry up and try to go file it. Well, once you find out that they're trying to register your name, we can challenge them, because it's whoever uses it first, not who files it first.
So if I okay, let's say if I file, you know, Chico Di Solo, right? And someone comes with something that says that's similar to mine, right? If mine is already registered, are you saying that we would get a hit, or we would get like an alert because we're already in the system saying, hey, this is something that's similar? How would we know that something similar is coming out there to put out that cease and desist to them?
Well, my firm offers monitoring services, so it is your responsibility to have a trademark and police and monitor it, because if you just sit back and watch people use your trademark, that's almost like you giving them permission. So I have a lot of people that say, oh, I see that Jane is using Jane on Instagram and she's selling shirts, but she's selling them out of the trunk of her car. I'm not going to bother her. And you have Jane for a trademark. Well, by the time Oprah says, I love Jane's shirts, and she's selling it out the back of her car, you say, wait a minute, that's my name. Jane's going to say, hey, you let me use your name for the past 10 years. So that means that you gave me permission to do this. So
now,
yeah,
now,
you got to watch it.
Now, for selfish reasons, I have to ask you, all right? So my trademark, that's once everything gets approved, everything with you, does that monitoring system come with that, or is that a separate thing?
It's a different service, so we're going to talk about that. But okay. What you can do for free on your own, so for, just the tip, is you can do Google alerts. And so, right. You can put that in and that can alert you, because you're absolutely right. By the time somebody finds out that somebody is using their name, most of the time it's because somebody has already tagged you in something and said, congratulations on your award. And you're like, this right. isn't me. Or right. they're complaining. I bought right. a shirt and it had holes in it, and you look at, you're like, you're not my customer. So it's too late. So here's the thing. If you can monitor it and catch somebody before they really start and say, hey, I see you trying to use my name, they're right. more likely to stop. But if you try to make me stop after 10 years and I have thousands of bottles of perfume to sell, I'm not going to just throw that away because you tell me to stop. I'm going to fight you.
Yeah, but they can't tell me to stop. They would have to have a trademark registered in order to tell me to stop, right? They can't just, if they don't have a trademark, they can't tell me to stop, right?
Well, they can if they can prove they used it first. So even if you don't have a trademark, so somebody can be in business for 10 years and say, I'm ready to go trademark. And we look and I say, oh, I'm sorry, Bob already filed that. We look at the date that Bob said he used it. If you can prove you used it first, you can challenge him. But the challenge is litigation. So it's going to cost you more than it would to just go ahead and have the trademark registered.
Oh, so what I'm saying is that person that's basically trying to refute my mark, they would have to have a trademark themselves, right?
No.
Wow.
It's whoever used it first.
Okay. I didn't realize that. Okay. All right.
Yeah,
Good information.
A lot of people don't understand that, because they'll say, I see somebody using it, but let me hurry up and beat them. Even if you beat them to filing it, and you're signing a legal document to say it's yours. So you got to be careful, and they can challenge you for it. Okay. Yeah, and that's exactly right. Somebody said that's why they need service. This is exactly the reason you need to hire an attorney, because everybody thinks that it's simple because it's a form. What's your name? Right. What's this? But the answers are, it's a legal document. And right. so when you are sued or challenged and you're sitting on that stand and they're deposing you and they say, why did you put this? You can't say, oh, I didn't know. Ignorance of the law is not an excuse. And really, y'all are here, so you really don't have an excuse. You
don't have an excuse, exactly.
You have a resource. So
right. That's why we're doing this. So somebody asked in the chat, podcasts are really big now. Of course, blogs as well. How would you go about protecting them? Would it be more so copywriting, trademarking the podcast name? Like, what would you suggest with that?
That's it. You got it. So the brand is going to be the trademark. So the name of the podcast will be trademark, and then the content will be copyrighted.
Okay. All right. So let's see. A comedian asked me this. I have an EIN. I have an S Corp. And now I'd like to trademark my business name, stage name, and a few phrases. How do I go about doing that?
Yeah, so we've been talking about that. I work with other comedians and entertainers, and that's really interesting, because what happens is when you have an expression that's going to go viral. So, comedians may have a saying that they say in between every joke, and, people are going to be walking around saying that. Right. You can't just protect that expression. It has to be tied to a product or service. So that's why we see in rap music and stuff, they have different hooks. People can literally take that hook and go stamp it on a shirt, and then it becomes a brand. But just you singing a song, or just you being a comedian, that content is protected with the copyright. So for me to infringe your copyright, I need to literally copy your jokes and paste them on my site and use them. But for me to infringe on your trademark, I need to have something that sounds the same, looks the same, has the same commercial impression. So everything that he's doing can be trademarked if it's used as a brand. So if you're going to stamp it on, remember, you can't just trademark a word. It has to be for a product or a service. So what are you going to sell? What service are you going to provide?
Okay. Okay, but you can, so if it's a phrase like someone just said, like where the money resides, if I wanted to copy, would you copyright that? If it's a phrase, would you copyright or trademark that? Or
You
you can't
can't,
even do
you
it?
can't, you cannot copyright a word, and you cannot copyright a phrase. So it's not going to rise to the level of creativity. So where the money resides, guy did is he had that viral expression, but his song would be copyrighted. So technically, that's what we see. You know, I ain't got time for that and all those different expressions. None of those people protected it as a trademark. So all of a sudden, you saw all of those shirts. Well, he actually got a trademark lawyer and said, all right, this is my saying, where the money resides. So I'm going to file it for, you know, shirts, this, and that. So once he gets the trademark, when you put where the money resides, it's just like Nike, you know, just substitute where the money, it's the same thing. So the beauty of trademarks is a lot of this is kind of common sense because we spend money every day. So you can just look at what everybody's doing. Look at all these other brands. And as small businesses, we need to start treating our businesses like a business and not waiting until somebody does something. So you can use these trademarks as a sword, you know, to fight people off. And guess what? You can sell them. If somebody wants it bad enough, they have to buy it from you and they have to respect you. So,
true.
You know, that's the beauty.
I mean, that's the whole reason why I wanted to go live with you, because, you know, a lot of business owners, they rather kind of like, you know, start kind of backwards with not getting the paperwork done first, right? Hey, listen, I did that. So I'm just trying to help someone not make the same mistakes that I made, right? But I learned, right? So I'd rather pay a lawyer for peace. You know what I mean? Because trying to do it yourself is just, it's really hard because it's a lot of, you didn't go to law school. So it's a lot of, you know, jargon that you just do not know, right? And that's where the mistakes come into play.
Yeah, and you just focus on your business. You know, by the time you spend 8 hours trying to figure it out, that's 8 hours of money you could have made doing what you're good at. And we see that in business anyway. You're smart enough to answer the phone, but you can pay somebody to do that for a lower rate and have more money coming in for yourself.
Right. Okay. Someone just asked, I have a what? Utilitarian.
A prototype?
Yeah, utilitarian product idea. I have no idea what that is. I'm sorry. Do I need a prototype in order to get a patent for that?
Oh, that's a good question. And that's a good time for me to plug my next book.
Oh, Lord, plug it.
All about inventing. This is one of my best-selling books. This one is going to walk you through going from an idea to a real invention. I even have a patent sample application that really is one of my applications that turned into a patent for one of my clients. But guess what? You do not have to have a prototype to file a patent application, and you don't even have to ever make it. You don't ever have to.
I thought you had to have a prototype.
Nope. As long as you can describe it in a way that somebody can make or use it, you're good to go. So I have people that call me with napkins and say, this circle is the engine. This star is the motor. This, you know, so it doesn't even, you don't even have to have formal drawings. But what you do have to have is more than an idea. So I have an idea to be able to slow the screen down or push a button and see people pop on the screen. That's an idea. But the invention is going to be, if this happens, then this, you know, like an actual way of how to do stuff. You know, like you have to describe it in a way. So some people like to, you know, make things to prove it. But here's the other tip about for the inventors out there. So with inventors in the patent system, it is the first to file. So you need to file your patent application. You can't just sit on these inventions. So if you're not 100% sure how things work, once we do the research and we show that it's not out there, you can file a provisional patent application. Right. File it today, January 21st, 2021, and it's pending. And then you can come back and file the non-provisional. That's the one that's maturing into a patent. That's the one that can be examined. And here's the benefit. When you come back and file the one that's going to be given to that patent examiner, you can claim the January 21st, 2021 date, even though it's January 2022. So it holds your date for a year. And then all the patents that come after you, you know, you're not worried about because you need to get it in before somebody else does. So that they don't care if you invented it first. So all those people that say, I saw that on TV or I think that's my invention, it doesn't matter. It's whoever files it first. So you don't need to be sitting on these inventions.
So let's see. We have we have to answer it because AKA had a question, so we have to answer her question. It says, what is considered use in commerce? When you make a sale or when you first use the mark? That's a good question.
That's a really good question.
Yeah, that's why I went back.
It's so it's not when you first used it, like you said it in a speech or you created your business. When we're talking about use, the question is, when did you use the trademark that you're filing on the goods and services in and out of the state? So you file a trademark, Andrea, for shirts, and you're based in Maryland. Well, your first date is today, January 21st, because Jane in Maryland bought a shirt. But February 1st, Bob in Texas buys my shirt. So now that's my first date of using the trademark outside of the state.
Okay.
So you have to keep up with those dates. Or if I sell a shirt today and Jane is in Texas and buys it, my first date of using the trademark is today in and out of the state. And that's one of the biggest reasons people lose trademarks, because if I challenge you and I say, show me how you used it, and you say, oh, I incorporated my business, or it's my nickname, I've been using it 40 plus years, that doesn't matter. That's not the date they're looking for. It's when you first use the trademark. And that's in my book too, or you all schedule consultations.
Pull it out.
Hey, and I'm only saying that because I speak to so many entrepreneurs and business owners, and I know that sometimes people say, hey, I'm not in a position to have a consultation. So you can just get the books, and they're on Amazon, they're on my site, and check them out.
There you go. How long does a patent last? Is it 7 years, or how long is it?
20.
20 years. 20 years. So when a patent runs out, can someone else go in and try to renew the patent under a different owner?
No, then it's just fair game. So that's what we see with pharmacies, pharmaceutical products, right? When you go, you think about albuterol, they have a patent on whatever.
That's when the generic comes.
Exactly. Right. So once it expires, it's fair game. And that's a good point, because I have some people that come to me with inventions, and we see that the patent is expired. So that means it's fair game for you to make it. Now you focus on the brand and the name. Right. So you want to sell pencils with cameras in it, and it's fair game for you to do it. So you come up with a name for that. We trademark it, and then you go from there.
Okay. All right. How long does it take for a trademark or patent to clear?
Oh, okay. So yeah, this is a great question, because it is a process. So there's really no sense of urgency, unfortunately, for trademarks, because you can't even expedite them. When you file them, it can take almost a year for the whole process, even longer if you haven't used it, right? Because they're going to wait for you to use it up to 36 months. So it could take that long if it takes you that long to use it. But on average, it takes a year. But here's the thing about filing patent applications. When you file a patent application, it can take them 2 years at least to look at the application. That's just to look at it, because it's such a huge backlog. Now for patents, though, you can pay extra and move it to the front of the line where they look at it in 1 year or less. But still, it's at least 1 year. But otherwise, if you don't pay extra for them to expedite it, then it can be 2 to 3 years just before they look at it. And no, once a patent expires, you can't refile it. And once a provisional patent application expires, you can't keep filing those provisional applications. A lot of people say, okay, mine expires January 2022. Well, I'm going to file it in January 2022. When it expires, I'm going to file another provisional and another one and another one. Once you make a public disclosure or you file a patent application, you have 1 year to file, or it's given away to the public.
Okay, so once someone said he or she already has a provisional already, at what point do they need to file for the non-provisional?
As long as it's within that year, because they only last for 1 year. If you miss that year date, that's it. So yeah, it goes in abandonment, or it's just rejected? It's abandoned. Wow. Okay. And you can't repatent nothing, right? Well, the provisional holds your date. The provisional, so remember, the provisional just holds your date in line. So it's never examined. It's just kind of a placeholder. You have to come back and file the non-provisional. That's going to have claims. That's going to have drawings. And the non-provisional is the one that the examiners see. So we want that non-provisional to date back. So what my clients do is they say, look, I'm going to go out and talk to people about this or help get somebody to help me make it. And then you feel good about that because you confirm that date. So when I go talk to Bob the builder, I can say, hey, Bob, I'm talking to you about my patent pending invention. You know, so now Bob can't go rush and try to file something.
Okay. Okay. All right. So someone, can you put the name of your books up again?
Yes, yes, yes.
That should be an issue.
All About Trademarks.
I think your husband's on. Is your husband on?
Yeah, that's my husband.
Yeah. Tell him to drop the name in the because he's doing an excellent job with plugging the office. Can he drop the name of the books?
Yeah, I see you did that. Thank you. And then I haven't told y'all about this one. This one is my newest planner and journal. So if you are an inventor, I created this quarterly planner and journal all about my invention. And this is amazing because this is the first ever journal and planner specifically for inventors. So they can not only document how they're feeling, but they can document who they talk to, you know, when they talk to them, what else needs to be done. Because what I found is that you're all over the place as an inventor and can't remember who you talk to. So you can also check out this on my site.
Okay. So since we're talking about books, right? Someone has several ideas for children's books, right? And I'm sure it's a lot of people that's on this live that probably, you know, they have ambition to write a book. What's the first steps to getting the ideas to reality? And what's the budget if you're going to, I guess, get the book copyrighted and all that?
So the Library of Congress fees are $65 per application. And so copyrights are a little different because they don't read your book and say, oh, this sounds like Andrea's book. They just look to make sure the application is correct. So you're going to have to pay those fees and ensure that the application is correct. And then that process can take a year. Now, to that author, though, if one of those characters you decide is going to be your brand, right? So I'm going to write a book about Mickey Mouse, and then I'm going to take my character out and put it on shirts and backpacks and sell stuff. Now that character can be your logo, and then we can trademark that character for products. Now, here's a bonus. Because I like your crowd. You know, we got a good vibe going with all these good questions. I got
a lot of good questions.
A lot of people don't know that you can actually trademark a series of book titles. So you can, normally you have a title and you write a book, How I Became a Lawyer. You see the same title by Attorney Chris, and he wrote a book, How I Became a Lawyer. But if I have a series, Harry Potter, the Sorcerer, Harry Potter, the Wizard, Harry Potter, whatever, now I can trademark Harry Potter. So if you write a series of children's books, you can trademark that title. So that is a big bonus because people don't recognize that.
That was dope. That was dope information. Somebody had a really good question. If you have a patent, does that keep the Chinese or Asian companies from importing the same to or basically doing the same thing over in Asia or, you know, internationally?
Yes, so, that is a great question.
Good question, yes.
Every country has their own intellectual property laws. So there's no such thing as an international patent. There's no such thing as an international trademark or international copyright. So if you have a patent in the US and I go over to China and I make it in China and only sell it in China, you can't touch me. Wow. But if I go over to China, make it in China, and they ship it back, and now Bob is selling all my stuff, now you're in the U.S. and I can touch you.
So if they make it in China and they sell it in China, I can't touch them. But what if my manufacturer is making it in China? It doesn't matter. You see, I tried to slide it in there. Okay. Right.
No, but I'll tell you this though. I actually have clients all over the world, and so if you reach out and you do want to protect it in other countries, I can help you to work with our counsel in these other countries that we work with, and we work together. So I'm a U.S. patent attorney. I'm a U.S. patent, trademark, and copyright attorney. We work with someone in China that's a Chinese patent attorney. So, but you have to make sure you're keeping up with the deadlines and everything, because once you get a patent in the U.S., it's too late to file in China. So everything is 1 year for patents. Once you make that first filing, you have to file in all those other countries. Or, and I don't want to get too technical because I don't know how many inventors we have, or there's something called a PCT application, Patent Cooperation Treaty. We can file here in the U.S. and then hold our date in those other countries. And so that's a
Wow.
strategy. So
Hey, what is that called again? What is that called again?
The Patent Cooperation Treaty,
Jeez.
PCT.
Okay.
So there are a lot of countries that are part of that treaty. And so you pay more fees to kind of have this application, but it's a strategy because then let's say you want to go talk and you go to a trade show and somebody from France says, oh, I love it. Can I work with you? Well, you don't have anything to license to them if you only have a U.S. one, so they can technically take it, head over to France and go and do what they do with it, without you doing anything about it.
Side note, this is probably why it's beneficial to have a lawyer, because the jewels that you are dropping, like I've dealt with like illegal Zoom and all these other ones, right? You're just not going to get this information, right?
Yeah.
So you're really still kind of like on your own. Like you said, it's like they're just cutting and pasting things. Like some of the things that you just said, I've never even heard of. And I wouldn't have heard of it unless I actually sit down and talk to you and you kind of lead us in the right direction. So again, definitely appreciate it. Just got 2 more questions and I can let you go. All right.
Thank you.
All right.
And thank you, everybody. I see all the comments and it's a lot of them. I appreciate all your
it's a lot.
questions.
It's a lot. Yeah, you should have some people want to buy your books. I keep hearing they're going to buy your books. So
that's good. Right. They can buy the books, but I want you all to schedule a consultation and not count yourself out, because people will assume they can't afford an attorney. And I have clients that schedule a consultation, find out what it's going to cost, and they may save $1 a day for whatever and come back, but the worst thing is to say, I can't afford this. And the reason I say that, when you talk about a trademark lasting beyond your life and all that, it pays for itself. And
it's a flat fee, right? Flat fee, right?
Seriously, when you think about it, and I'm only saying that because honestly, I make more money when you don't do it. Because when you come to me and say, I got to sue somebody, I'm making more. So I'd rather empower the community, because they just published a study at the Patent and Trademark Office saying women and minorities are the least likely group of people to protect their intellectual property. And you know why? Because nobody's talking about it.
That's why we're here.
Yep. That's why I'm so passionate. That's why I'm here, because these are not my office hours. But when I had this opportunity, I had to definitely come on and talk about it, because I saw that so many people were interested in it. People have questions, and we just don't know what we don't know. So I'm
and that's the thing. A lot we just don't know, and we kind of go with what we hear or what we Google. 9 out of 10 times it's just not right. So that's why I'm very, very fortunate that you took the time out to speak to us. Thank you. But this is something that you didn't talk about yet. So what do you suggest when someone has filed, right, and they get a denial? So talk to them about that office action when it comes in, and explain what it is and all that.
Well, which one, for trademarks or both?
Both.
Okay.
Both.
Well, so for trademarks, honestly, we can help to prevent that, because before you file, there are things we can do to research, and there are ways that we can narrow our scope or broaden our scope to try to avoid something. Now, sometimes you can't prevent getting a rejection. And let me explain. And I know this because I was a trademark attorney. Now, it's very subjective, because remember, for something to be confusing, it has to sound the same, look the same, have the same commercial impression. But just because they say that doesn't mean they're right. Now, a prime example is one of my biggest cases that went viral around the world that you all probably heard about. The rapper and producer, Dr. Dre, sued he lost because he sued my client, the OBGYN, Dr. Dre, DRAI, for trademark infringement, because he said these names sound the same, and said my gynecologist client was trying to play off of his name when that was really his name, and we won. And so after this live, because maybe you missed it, you must have been under a rock, because this went viral around the world.
Wait a minute, because I remember. All right, so I'm old enough to remember Ed Lover and Dr. Dre. Like, I remember, I thought that he sued, or Dr. Dre tried to sue him for coming out with Dr. Dre. I didn't know Dr. Dre tried to sue another real OBGYN doctor.
Yeah, hey, guess what? I threw that Dr. Dre into his evidence, because I'm old enough to know him too.
Right.
Said, wait a minute. He's Dr. Dre, but not only that, his name is closer to being the rapper anyway, because one's a DJ and one's a producer. So for one to be a medical doctor, but I say that to say that don't get discouraged, but what I'm also saying is that I want you all, if you want a good laugh, because the memes were hilarious. You know, when you see Dr. Dre, the billionaire meme mug, and you see my gay gynecologist. And so part of our argument was just that one is homophobic, one is, you know, a gynecologist, one. And so it's a good example of analyzing likelihood of confusion. Does it sound the same, look the same, have the same commercial impression? But here's the thing. If you hire an attorney to do your trademarks, I can help you to foresee what's going to happen, you know, so that shouldn't happen. But for patents now, that's a different story. And the reason I say that is only because 90% of patent applications are rejected the first time. But that's just the nature of the patent office. If you have something in there that we can pull out, so if you file an application and you say, I have A, B, and C, and then they find A, B, and C, and you say, wait a minute, but I have D. If D is written in your application, we can add D and get you a patent. So that's going to help you. But here's the catch. If you don't have D in there, we're screwed because we can't add anything else to that application. So that's why the most important thing you can do with your intellectual property is research it. That is the most important thing. So don't be discouraged when you get an office action. There are so many people that file on their own, and when they get that rejection, they count themselves out. And if only you hire an attorney to look at that, it could be something so simple for an attorney that has that experience. So that's another reason why you need an attorney, because when you see it, it's a lot of legal jargon and it looks like a lot and you feel intimidated. And then you consult a lawyer and it's like, oh, just remove this word or just add this and you're fine. It's like, oh, that's it, you know, so don't count yourself out.
Okay. So talk to us about the consultation fees. To everybody that's on here, that I'm sure they're thinking about, I need to reach out to her tomorrow. What's that process once they call your law office? What's the consultation fees like? What goes in when you're consulting and all that stuff? Like, kind of like break that down.
Yeah, well, I have the best consultations around. I'm only saying that because I know with confidence that I go over and beyond, just because I know what my colleagues are doing, and I don't want to leave you all out there. So
you were fussing at me. You definitely were fussing at. You were fussing at me on that Zoom. You definitely was. You got me straight quick.
But you smiling now, aren't you?
Yeah, I'm chilling. I'm good.
Yeah,
that's why I'm here.
And so that's the thing. I'm very honest, but that's what you want in an attorney, because when you know, I understand what it's like, because my businesses are my babies, right? And it hurts your feelings, right? It hurts your feelings when somebody says, I'm sorry, you can't use that name. And you're like, no, but this is my name. It's my mom's name and my grandmother's name and whatever it is, you know.
Right.
So I would just say, I forgot the question. I'm sorry, I got sidetracked.
No, I was saying that we know for the folks that's on here that are actually eager to reach out to you, talk to them about the consultation fees, talk to them about, you know, I guess the process of the consultation and, you know, I guess the steps to dealing with you.
So because we represent clients around the world, the way the process works is in my bio here. You can click on the link and click on the schedule a consultation button, and you'll fill out a form. That form is going to go to our intake coordinator, and then they'll email you a consultation form that explains what's going to happen, and also an intake form that allows you to then upload information about what will be required. And what I'll say is I prefer that you all fill out that form, and then they'll email you back the fees, just because I do so many interviews that I know they live forever. And once Oprah calls the firm, the rates are going up. So y'all better get in now. I can't give y'all the exact rate now, and then you try to hold me to it, and you'll be saying, remember when you were on Chico's thing? But there is a fee. There is a fee for the consultation. And I will say my federal trademark is invest in your idea. So you have to invest in it, you know, and those quick questions that you have and all that, you need to really make sure that you take the time to understand your options and not count yourself out. And I see Ivy laughing, and Becky, it is true. You know what it's like. You know what I'm talking about. But attorneys charge fees, but they're very reasonable, you know, and I will say that. And Mills Unscripted, that's funny that you say that. She said DRE Dre doing a pap smear. That was
Ew.
one of the memes. That was one of the memes. So y'all have to look that up. But
Wow.
I will say, you know, honestly, I see people saying Oprah. Oprah would be a good client, but honestly, I am very fortunate to have some amazing clients, you know, whether they're celebrities down to John in the garage and Chico, of course, for wanting to even have it. I mean, that's saying a lot, you know, because honestly, a lot of people will just be selfish with the information.
Right.
And so I want to thank you so much for the opportunity to present this to your community, because so many people, I mean, because we hang around like-minded people and people have questions. How did you get this done? Who did you talk to? And half of the battle in business is the community that you have and the people that you surround yourself around. You can throw away money, but why do that when you already have the resources and people that can help you?
Well, one thing that we do, I would say, within our community, within the African American community, we hate to give up the plug, right? So you are the plug. When it comes to this patent stuff, I feel like you are the plug. So that was the whole thing, just like give this free game out to people so people will understand the importance of getting your paperwork together. So you want to talk about your social media and your books before we leave?
Yeah, please. I'd love to keep in touch with you all. So I'm Evans IP Law all over social media. I do have a newsletter, and I'd love for you all to join my newsletter. You can text Evans IP Law to 33777. And when you text that, you're going to join my firm's newsletter. I have over 14,000 plus subscribers. And I'm very proud of that because I'm a lawyer, right? So people say, what are you putting in this newsletter that makes people want all this information? So I give out information like this, but most importantly, I tell you all about funding opportunities, pitch shows, opportunities for you to compete. I'm on a PBS television show, Make 48. And so inventors have 48 hours to solve a problem. I'd love for some of you all to be on the show. So I'm on seasons 2, 3, and 4.
Oh, wow.
You can check it out on demand. It's on demand now, or you can just go to make48.com. But it's a really inspiring show because they basically give out a subject matter and then teams compete, you know, in 48 hours. And I'm the patent attorney on the show. So it's going to actually give you a glimpse of what I do. You'll see me in action and see me maybe have to tell you no, but I smile when I say it. And, you know, that helps. So, you know, check it out. But I definitely hope that you'll join the newsletter. You can always go to evansiplaw.com, but you're going to text Evans IP Law to 33777. My books are also on my site. All About Inventing is a great resource that walks inventors from going from just an idea to a real invention. So you can check that out at evansiplaw.com/books. And then All About Trademarks basically walks you through creating a brand and understanding how to make it strong. It has that identification manual in it that walks you through the class numbers and helps you to understand what those questions mean. And then All About My Invention is a journal and planner, a quarterly journal and planner. And all of these are on my website, evansiplaw.com, or Amazon.
Okay.
So maybe I'll do a special tonight because I'm just feeling like the community, you know, needs this information. So I'm gonna do
what you doing?
I'm gonna do a buy one get one free.
Oh man!
So you buy the trademark book. I'm gonna just go ahead and throw in the invention book if you buy.
Say that again. Say that again. I don't think they heard you. Say that again. This is only happens at Chico D Solo for the free game segment. Go. Just say that one more time.
All right, yeah, because I'm feeling generous. I mean, we've had so many people just ask good questions, and everybody's so engaged. So if you go to evansiplaw.com/books, if you don't have to put in a code or anything. When you buy one, I'll go ahead and just throw in the other. So it doesn't matter which one you buy. This is going to be for All About Inventing and All About Trademarks. Now, you still got to buy this one if you want the journal, though.
Right.
The journal's kind of heavy to ship, but I will give you buy one, get one free because I think that people need this information.
That's nice.
And they're so valuable, honestly, that the books really have empowered so many people. So I just say that once you read it, you know, tag me when you get the books at Evans IP Law and leave a review because, you know, she said, how will you know it's one of us? Because you got to buy it within 24 hours.
There you go. There you
All right,
go.
so you
And,
can't
and
think about it.
make sure y'all don't DM her no questions. I'm telling y'all right now, she's gonna say, please email me. So I'm telling y'all right now, I know y'all already be all in her inbox asking this, asking that. She don't do that. She gonna say please, and it's gonna be you gonna feel like she's talking very direct to you. Please email me. All right, email
Hey,
my staff.
you
Am I
gotta
right or wrong?
ask him, how does he know that? How does he know?
Because I
How
was
does he
all in
know?
the DM asking.
I mean, hey, y'all, I'm running a real law firm. So what I say is
Right.
just reach out to the office. But if you do need to follow up, like what's the link for something, or you have
Right.
a question, don't try to make people think I'm just this mean person.
No, I'm
very
just
nice.
saying. No, listen. Look, you know how black folks are. I can already. Becky Brown probably get ready. Email you something right now. I mean, text you something right now in your inbox. So
Hey,
I'm trying to.
she wrote thank you in all capital letters.
Yeah, I'm telling you, right. So go to her website. Go to her website, and you get her bio. Her email's on there. I think her husband might have put the email in the chat. If not, he's a noob, so he probably didn't do it. Your husband's a noob, right? He a noob,
Yes,
right?
he
I
is.
saw him say, "Yo, yo." Is he a noob?
Yeah, he's a noob. And
All
I'm a
right, okay.
Delta.
I almost kicked him out the thread because he knew, but because he's your husband, I let him stay.
So somebody said, I'm located in Maryland. My physical office is in Maryland, but I represent clients all over the world, so you don't have to be local. And of course, we're Zooming, so we can schedule a Zoom consultation or by phone. So I don't even go into my office anymore with all this stuff going on. And then the journal can be for multiple ideas because it's set up.
Thank you, sir.
It's monthly. And it includes a checklist, and it has an outline, but let me just show you something real quick. Like, it lets you describe your invention, so it's kind of some general questions in there. But then it has the patent application checklist. So this is really empowering because what I like about these books is I wrote them from the perspective of working at the patent office and getting questions, and then now having a firm and getting questions. And I just packaged it all in one book, and I wanted to make it affordable for people because you may be watching this saying, hey, I do need more information, and it's a lot of misinformation. So, these are going to be good resources. So we'll do a buy one, get one 24-hour sale. So what's the date in case you show
yeah, hold up.
replay?
It's the 21st. It's the 21st.
Okay,
So they got it to what?
By the 22nd, y'all got to do the BOGO.
9:15 tomorrow. They have to they can get the buy one get one free, right?
Yeah, that'll be
okay.
Good.
And for all y'all shameless plugs for all the HBCU people out there, Gain Sports Gear is running a sale for the HBCU hoodie. So if you don't have one, let's go to gainsportsgear.com and grab that hoodie while it's on sale. We only have a few small and mediums left for the ladies. The men sold out in 48 hours. So
that's great.
Yeah,
and look,
we gotta get you one.
So where are your sweatshirts? You gotta hold them up.
Well, hold on, I'll be right back. I ain't gonna do it. This is all about you. My wife is probably gonna get mad at me now because I did my little plug, but I mean, I'm just letting y'all know.
Good. Yeah, because I have people in my community watching too, and it's important because we have to support each other's businesses, and we need good cozy sweatshirts,
Right. He said, say the website one more time. This is your husband, so I have to listen to him. It's Gains, GAINZ, Sports Gear, SPORTSGEAR.com. It's in my bio. It's in my bio. So we have it for the women because the men are sold out, but we do have some that's in production right now. We have sweatsuits and everything. It's in my bio, 1963. It's in my bio. We must be an IO. That's why you're asking again. IO, go to my bio, bro. You'll get it. You'll get it.
Yeah, but I love it. We got to support your brand. We got to definitely treat our brands like they are going to be million-dollar brands. And I want to say this because often people count themselves out because they say this is a hobby or I'm not making a lot of money. You don't have to be making a lot of money. I had a client that only had $20 per year, and somebody wanted that name so bad they paid him 6 figures for that trademark. So you have to just have continuous use, and you have to be doing business in and outside of the state. And everybody's doing that. Like nobody's limited now, of course, to their states because we all have the internet. We have social media, so we have to take advantage of that.
Have you ever had an issue with, I guess this is a side talk now, with you being a lawyer, being a female Black lawyer, have you ever had someone within our own community that felt like they would rather use someone from a different culture versus you?
Hey, I wouldn't know because they paid that money. So the people that want to talk to me want to talk to me. The ones that don't, I mean, that's how I have to be with life. Like I basically focus on the people that are positive and the people that are supporting me. I can't worry about, you know, what the people say that don't want to work with me because I wouldn't know because they're not working with me. But what I will say is, check out my testimonials. You know, I love my clients just as much as they love me. And I love being part of their team. You know, I get to be an extension of their team and I take it very serious. So that's it.
It's just funny you said it is very important that, you know, we support our businesses. I just remember when I first started Gaines, you know, the guys, my friends, when my product, actually, it's in like 12 different locations now, right? But one of the gyms was carrying my product. I was so pumped up because my product was like right on the same shelf as Under Armour. And I went to one of my buddies, like, hey, man, my joints are right on the shelf. He's like, all right, that's cool. But then when I went to someone else of a different ethnicity, it's like, oh, for real? Oh, man, it's a Maryland brand. I'm supporting it. And then it came legitimate when he saw someone else with it. So I just don't understand why it's that mentality. I just wish we could. That's why I have you here. I just, you know, we have to share the plug. We have to, you know, support each other. But I guess we'll get around to getting everybody in that way of thinking.
But you know, you got to focus on the people who support you. And I say that to all the entrepreneurs listening because we often form businesses and have products and you immediately assume that all your friends and family are going to buy those products. And when they don't, it hurts your feelings because you assume you're my friend, you're my family.
Yeah.
That's not why you started the business anyway. So you have to figure out who your ideal client and customer are, and you focus on that. And once you recognize that, all that other stuff, that negativity, it doesn't matter. Because you're not thinking about that. You're focused on the people that are investing in you and that are supporting you.
That's true. That's one thing I can say about you. You be having blinders on. You only focused on the business. You're not about no mess. When the mess comes, this is what you're doing. You only focused here.
I mean, hey, but I have to be because otherwise I would not have made it 14 years as an African-American woman owning an intellectual property law firm.
Right,
just
your own right.
To be a patent attorney, you have to have an engineering degree. And so,
oh, I didn't know that.
Yes. And so a lot of lawyers and African Americans are already counted out because we're the community that's least likely to have a STEM degree. And so, you know, we got to think about that. So it's only 1% of intellectual property attorneys are African American.
1%?
Yeah.
Jeez, y'all not even filling up the room. Okay.
Exactly.
I get it. Okay.
But which is why it's important to find an attorney you can trust and one that has a lot of good experience, because honestly, with the experience that I have, my colleagues are constantly offering me jobs at their mega firms, but those are the firms that don't invest in the community and individuals. So what you're going to find is you're going to Google it and see that there's a bigger firm. And when you call them, they're going to say, sorry, you're too small for us. And then hopefully they're going to refer you to my firm. So, hey, and what I like to say is everything starts small. So all small businesses have to grow. And when you have an attorney that believes in you, you know, my clients are loyal to me just like I'm loyal to them. And we just have grown together in these 14 years.
Okay. All right. Well, y'all, I don't know. I mean, I can't end it no better than that. So if I could leave y'all with one last gem is invest in yourself. And if you have a brand, if you have an idea, you see this sister right here. She definitely will lead you in the right direction. So make sure you reach out to her to talk to her about that consultation fee. I promise you, just from the consultation fee, she's going to have you thinking differently, right? Like she had me change some stuff all the way around, but I was going to mess all the way up. So I'm very, very fortunate for that. So thank you so much. I have to get my wife to get, she has to get the trademark with you as well. So we got to get you talking to her. And we got to get one for Brooke.
Yeah, exactly. Hey, but that's amazing because when you think about these trademarks and all your intellectual property, you can will it. And that's what I love about this, that you have that option to create a legacy. And we need to think about businesses, but we get businesses to empower our community and leave a legacy for our families. And so that's what you can do with intellectual property.
Okay, well, I'm gonna have Brooke reach out to you because she be paying for her own stuff. I'll have her reach out to you.
Hey, my youngest client was 7, and
really?
now she's 21. And when she was young, she actually got the Nickelodeon Teenpreneur Award and was, I mean, so I don't count children out. And in fact, their children have such broad ideas with no limitations that when your children are coming to you with these amazing ideas, don't count them out, because a child invented the backpack on wheels.
You did say that, right?
They got tired of going to school and lugging that heavy backpack and said, oh, why can't I roll it? And that parent invested in it and got a patent on it.
So if you do have a child that's like in the industry, you would definitely suggest them trademarking their name or their likeness, right? That's
right, because entertainers do it. So whatever service, you know, she's going to provide classes on how other kids can do it. And, you know, so the opportunities are endless with the brand, especially when you have a name, because, right, you think of, my daughter's name may be Chanel. Well, if they have Chanel trademark for purses, now she can't stamp Chanel on a purse. You know, so if you own that name, it's so much value in that name, which is why we saw the billionaire trying to stop the doctor. You know, it's a brand. Like, it's, you know, once the floodgates open and you start letting a lot of people use variations of your name, it becomes a problem.
Right. Okay. All right. I appreciate you for this opportunity.
I think Chico's trying to get client of the year. I see some of my clients on here.
Do you really?
Yeah, I see them, and, you know, I can't say favorite clients and all that, because y'all know I love all of you equally.
No, I'm the favorite client. I didn't pay to get to the front of the line. You know how you said you paid for the patent to get in the front of the line? I didn't pay to get in the front of the line, right? I'm the favorite client.
Yeah.
That's all. We'll share you.
Thank you so much. And, you know, just continued success to you and your business. And
thank you.
It says a lot about you for you to take time out of your schedule to talk to everybody about this. You know, this important.
It's important. Hopefully we can do it again. So
yeah, let's do it again.
Thank you. Y'all go get her books and reach out to her, but stay out of her DM. Be gone.
All right. Thank you.
Thank you. I appreciate you. All right, y'all.